Every week we receive hundreds of new requests for legal advice from school principals, and they range from subpoenas to produce documents, discrimination complaints, disciplinary appeals board hearings involving staff who've appealing termination decisions, trespass orders, social media requests for advice, personal injury and property damage claims, family law queries, personal safety intervention orders, advice on school council procurement, advice on obtaining a personal safety intervention order in relation to a parent with challenging and difficult behaviours, and advice on expulsion and suspension of students and privacy requests. And we know that for school leaders, focusing on whole school performance, teaching and learning outcomes and strategic priorities should be your focus. We know that dealing with difficult parents, complaints, litigation and disputes is distracting and stressful for school principals, and it creates a risk for the schools and for the department. And that's why we see it as our job to take care of the legal questions so that you can focus on school outcomes. But what I wanted to say today in my introduction is that as principal, you are the school leader and you are the decision maker and you're the figurehead of the institution. And that's very important in the legal context because we are really your invisible friend. We're your ghostwriter and we're your enabler. So the best thing that we can do is to give you practical, useful and solution-focused advice to help you to make the best decision and for you to deal effectively with that legal challenge. And you're the best decision maker because you know your school community, you understand the dynamics between school council, parents, staff and students, and you can have proper regard to these countervailing interests. And you're the operational expert. We are not the operational experts. And when we go to court and when we have investigations from the Ombudsman, the Privacy Commissioner, the FOI Commissioner, the Auditor General, when we're in tribunals, they are all interested in the reasons for your decision. They're interested in your professional judgment as the person in charge. They want to know, did you have regard to relevant considerations? Was your decision reasonable? And what steps did you take to manage the risk? They don't want to know what the lawyers said to you, and they don't want to know what the legal advice was. In fact, the legal advice is confidential and legally privileged. So in most cases, they will never see it. And this is really important because what we often do is help you to write a letter. We help you to communicate with staff, but you'll be owning it, and you need to own it because you're the best person to own it. But that's also what is the best way to manage risk and to manage the matter if it becomes litigious, if it becomes a dispute, if there is a third-party regulator inquiring and looking into what happened, why was the decision made. And so if you call us or you email us or you attend our presentations and you follow our advice, you will be able to reduce the risk of legal challenge, dispute and litigation. You'll be able to know and understand what you need to have regard to legally when you make a decision, and you'll be able to make a sound, defensible and rational decision. And you can focus on what you know and what you do best, which is being a school leader. And so we do come out from time to time and do presentations on topical issues, but while we're here, we've got many, many lawyers back in the legal division speaking to school principals now and giving them advice on a range of different issues. And two of the topical things are around social media and also around managing complaints and disputes and litigation, and that's what we're going to talk to you about today very briefly. Before we do that though, I'll just remind you a bit about the legal division and the way that we're structured. We were established only in 2013. There were always lawyers in the department, but we were dispersed in different parts of the organisation, and with the big restructure that happened, all functions were consolidated into one legal division. And that's when I became the executive director of that legal division. And since then, we've been really trying to focus on communicating concisely and practically and usefully to schools to focus on helping schools to be freed up to focus on school performance rather than be dealing with distracting legal disputes and matters. We have our internal Educate page, and on this page here, which we will be revamping soon, we have fact sheets, we have information for you, frequently asked questions, we have templates, we have information about our services, and I would encourage you to go to our Educate page for information. And here are some of the examples of the fact sheets and information sheets that we have, you know, around chasing up bad debts and tips for reviewing contracts, insurance, trademarks, fences, students with disabilities, school camp, attendance, reasonable adjustments, unfair dismissal issues, bullying, jurisdiction issues around the Fair Work Commission. And we also have a legal services catalogue which explains the range of services that we provide to schools. And I'd be interested to know from those of you who are here today, how many of you have seen our newsletter, Focus on Legal? A few of you, that's good. That's new from last year. We've been putting out a newsletter to schools, and I think one of them, recent edition, came out this week, and we've got one more before the end of the year. And what we do with our newsletter, it's about 2 or 3 pages, and it contains topical issues for schools. So when something comes across my desk or the desks of another lawyer, and I think there's a bit of a theme or a trend happening, I'll get someone to write a really short, punchy article about that with some top tips, and we pop it in our newsletter and send it out to schools through the Tuesday school bulletin. And you can also find the old editions of the newsletter, former editions of the newsletter on our website. And so examples of things that have been in our newsletter, you know, managing a claim by parents for student injuries, planning for excursions, bullying, part-time attendance with students with disabilities, school purchasing arrangements, etc. So one of the main units in the division that services schools is the Children, Families and Education Law Unit, and I've just got a description here about the main areas of law that they advise on, and I would say family law is a really significant part of the practice of the lawyers in that group, as well as child protection, mandatory reporting issues, trespass, duty of care, subpoenas, privacy and criminal law matters. And the Workplace Discrimination and Disputes Unit, they also service schools very heavily around employment law issues and disability discrimination matters and human rights issues, and they perform an advocacy role in courts and tribunals and commissions. So if you've ever had to go to the Equal Opportunity Commission for a conciliation conference or a mediation or VCAT, etc., you would have probably gone with one of the lawyers from the Workplace Discrimination and Disputes Unit. The unit also manages the personal injury and property damage claims that the department receives in relation to schools. And the Commercial and Property Law Unit, for those of you in particular, I think with large secondary schools, there's often business managers, and for primary schools, it's often the principal who would be contacting the Commercial and Property Unit in relation to commercial matters that arise in schools. So here's our phone number, 1 phone number and 1 email address, and we always have someone on duty between the hours of 8:30 and 5:30, and we will always make sure we have someone available to take a call and triage the request. So if it's urgent, you'll always get an immediate response, and if it's less urgent, it'll just be prioritised in terms of what else is going on in that day. And today we're going to be talking to you about social media and managing complaints and litigation and disputes. And it's my pleasure to hand over to Sophie Banks, who's going to talk to you about social media, and then after that Eve Bignall on complaints and litigation. Thank you.
Thanks, Kate. I thought I'd start today with a poem. And no, I'm not a poetic lawyer. It was written by an elementary student 3 generations ago for my great-grandfather, who was a principal in Coburg High School, and he wrote it before his retirement. So the poem goes like this. Mr. Sheehan is a very good man who goes to church on Sunday. He prays to God to give him strength to whack the kids on Monday. So I think if my great-grandfather was alive today, he'd be going to church to pray for all sorts of things, and probably strength to deal with cyberbullying and sexting and managing difficult parents, because that's a lot of what my unit is getting from you in terms of queries. So social media has certainly created a brave new world for all of you, and added an element of complexity to your work. So what I'd like to do today is to address one of the most common queries that my unit gets from you, which is inappropriate parent behaviour, usually on Facebook. So I'm going to get really, really practical and hopefully arm you with some tools in your toolkit to go away with, and next time you have an issue like that, you can deal with it. I would say, however, that my unit's always here, so if you do get an issue like that or any issue with social media, please feel free to give us a call straight away. We're here to help. We deal with this all the time. And if you get us on board early, it's one less thing you have to worry about in your day. So let's start by looking at what social media is. I've got a definition there that I got from the internet. Forms of electronic communication through which users create online communities to share information, ideas, personal messages and other content. And I've just listed there the various types of social media that exist, and they're sort of expanding every day. The most popular by far is Facebook. Apparently it has 900 million users, which is phenomenal. The next most popular is Twitter, and it only has 310 million. So it's not surprising that you as principals are sort of seeing the issues arising in Facebook because it's the most popular form of social media. So I think we can all agree that social media has real benefit, and I'm sure we all use some form of social media ourselves, but the challenges that it presents schools, from our point of view, seem to be either inappropriate behaviour by staff, other members of the school community or students. And I mentioned sexting before and cyberbullying, so that's a huge issue. But another a huge issue for you seems to be parents or members of the school community not being happy with the way the school's handled something and taking to Facebook or some other form of social media just to have a rant. And then it affects not only members of the community, parents, but also your staff, because often they're named. And even if they're not named, you can sort of put together who it is, and it's very stressful. This is a real-life case scenario that I've got up there, just so that you can see the sort of things that come up. So this was a parent who took to Facebook because they weren't happy with the way a member of staff was teaching their students about social media, and so they put this up onto Facebook as an example that you can put anything into social media and it becomes truth. So you can see the scientific name for this jellyfish is, and then they put the teacher's name. The teacher's name is located in southeastern Australia, most notably around Harrisfield. The teacher's name has long blonde tentacles that are poisonous. These jellyfish live in clusters and are most often seen in the summer months. It's one of Australia's most dangerous jellyfish ever. Unsurprisingly, this staff member was very distressed by this. So what do? Well, I think it's important to note that there are serious implications for this sort of behaviour. It's unreasonable, it's disrespectful, it's inappropriate, and you shouldn't have to put up with it. And this is that was just an example. I mean, we see all sorts of stuff, and often other people then get on board underneath and start putting their own comments, and oh yes, this happened to me, and oh you poor thing, and it just goes on and becomes this phenomenon. So, I mean, for a start, it's contrary to the department's policies and probably your school-based policies. It's most likely contrary to the terms and conditions of Facebook or the other social media form that it's been put up on. There may be criminal offences associated with the behaviour. For any staff members named, if they have concerns for their safety as a result of that, if they feel harassed or intimidated, they may have grounds for an intervention order. And there are other legal actions that could arise, such as defamation. So it's serious business. And as principals, you have OH&S obligations to your staff. And I've just put up there sort of a snapshot. I'm sure you all know what those are already, but it is to, as far as reasonably practical, provide and maintain a working environment that is safe and without risks to the health and well-being of your employees. So what do? I've just put up here sort of the top 7 things that we would suggest that you do. And again, if something like that were to happen to you, feel free just to give us a call straight away, and we'll just help you to navigate you through all of these steps. But what I'm going to do is just go through a couple of them in a bit more detail. So I think in this case, the first two steps are fairly obvious. We don't need to go into those. But in terms of what you would do to take steps to remove the content, the first thing you would need to do is, if in this case example, because it was on Facebook, you can go to the Facebook Help Centre and report offensive or abusive content to Facebook. Now, in my experience, you can do that, but they don't tend to take action. They've got, they seem to have a very low bar. So we've got on our website, through the Bully Stoppers page, a step-by-step guide to other things you can do, and they include, essentially writing to the person or having a meeting with them and asking them to remove it. Because Facebook's have a history of being ineffective in responding to these sort of requests, my unit's developed a letter that we can email you, that you can format for your own purposes and send to the parent. And I'll come back to that in a minute. So the next most important thing to do is to support the staff member who has been named or implicated in the post. And the sort of things you can do is refer them to the EAP, which I'm sure you're all aware of. You can consult the department's employee health unit, and the Learning Online website has got a step-by-step guide as to accessing wellbeing support for online incidents of concern. So that's really useful as well. Otherwise, as I said earlier, we can help you by providing you with a sample warning letter. It spells out, that the behaviour was contrary to our policies, that it was inappropriate, and essentially directs them to remove the content, with a warning about what might happen if they don't. In my experience, we haven't had to take that any further. Usually when a parent gets a letter like that, they kind of go, oh, they might have another little rant and then they'll stop. But we can also help you if this is a parent or a person in the community who's providing general difficulty to you, and it's not just isolated to this one incident. There are other things that we can do with you in the long term. It might be appropriate to put in place a communication strategy with this person. Put restrictions around their engagement with the school, for example. We can also assist you with a trespass warning letter if staff are so affected that they are concerned that they might be in harm's way if the person comes onto the school property. The next step would be a trespass notice, and then, depending on the circumstances, staff may want to look at personal safety intervention orders. So they're all things that we can assist you with, depending on the nature and severity of the incident and the ongoing behaviour. And I just popped up there too the new Educate Toolkit, Creating Respectful and Safe School Communities, Guidance for Preventing and Managing Challenging Parent Behaviour. It's really excellent resource that's got all sorts of really practical staged interventions in there, and includes in there, a warning letter. So for example, the trespass warning letter is included in those resources. So that's just quite a good go-to website for all sorts of parent behaviour. The other next important thing to do is to report the behaviour. And depending, again, on its nature and severity, and if you're not sure whether or not it constitutes a criminal offence, just report it to the police. Contact Security Services Unit. You may want to just let your region know. They might have some ways of supporting you as well. And then log it in EduSafe. It's really important to record all the steps that you take. As lawyers, we often say if it's not written down, it doesn't count. You can imagine if later on, you're in a situation where you have to recall what happened, it's going to be a lot easier if you can just look at your notes and your records, and they can be used as evidence of the truth of what you're saying as well. So just to finish off, what can you do now to sort of minimise the risk of this happening to you? It's a good idea, or something to consider, is to put in place, if you haven't already, a statement or policy about expected behaviours in the school community, to communicate this to the school community on a regular basis, and the last one might be a bit hopeful: staff and students model positive and respectful behaviour to the school community. So in terms of management strategies, usually the parents taken to social media because they've had some need that they felt hasn't been met by the school at first instance. So where possible, if you can get, when a parent's expressing an issue with you or a complaint, if you can get on top of it straight away, find out what's going on and try and deal with it at the earliest opportunity, it may stop them from sort of, taking it elsewhere. Managing expectations and implementing appropriate and effective and timely communication strategies. Now, that's all well and good. There is always sort of 1 to 2% of the population who just aren't reasonable, and that's why we're here, I suppose, to assist you. But all you need to know is that if you're following these sort of steps, you're reporting them, then you're doing what you need to do to discharge your duty of care, and that's all you need to worry about. And again, if this parent or the person who has made the post continues to cause a problem for you, give us a call and we'll help you. Thank you very much.
Well, good morning. My name's Eve Bignell and I'm in the Workplace Discrimination and Disputes Unit, and I will make sure that I finish in time for any questions of Sophie, Kate or myself on these or other matters. I'm here to talk about managing complaints, litigation and disputes, which is what the Workplace Discrimination and Disputes Unit does. This is our bread and butter. As Kate indicated in her opening, our unit of the legal division deals with both the front end and the back end side of disputes. So back end being we support principals in responding to grievances that have been raised in our areas of law, and every day that includes things like teachers who've come into the principal's office and raised a complaint about their employment, something that is probably beyond, when I say beyond, not in the area that human resources would support you with. So a complaint that is perhaps foreshadowing that the teacher might take it further, perhaps alleging that you haven't complied with your legal obligations about this person's employment, or we've got letters from parents or meetings with parents, or maybe grumpy letters from their lawyers or advocates. A lot of parents have advocates, especially in the disability space, and we'll provide support and assistance to you in responding to those letters. That's the back end work. Unfortunately, when things go south, we also do the front end work, which is we represent you in litigation. And these are the areas in which we operate. So discrimination, harassment and victimisation, employment, it's now the Victorian Work Cover Authority, used to be called WorkSafe, prosecutions. Unfortunately, as you hopefully are all aware, under the Occupational Health and Safety Act, there are obligations on the employer to provide safe workplaces, but there's also specific statutory duties on persons who manage and control the workplace, and for you, that is you. And WorkSafe, BWA, has a broad discretion, and they will, and it's probably about 50-50 we see, they'll either just go after the employer, or they might decide that any risks to safety are attributable to the conduct of the particular person in management and control. And on a work site, on a construction site, that would be the lead contractor or the developer. In a school, it's the principal, and we support you in dealing with correspondence with WorkSafe on those issues too. And Kate's mentioned negligence. Now, of the types of work that we do, we find that probably the highest area that we're supporting principals in is the discrimination space, and of that, the vast majority is dealing with students with disabilities. So that's the focus. And my top tips for principals in dealing with students with disabilities is make reasonable adjustments. This is a concept under the law. Not only do we have legal obligations not to treat people differently because they have a disability, and not to impose conditions on everybody that has a disparate effect on a person with a disability. and those conditions must be unreasonable. But there's also a specific obligation to make reasonable adjustments to enable a student with a disability to participate in their education, to access their education, to participate in educational activities, and that includes non-core curriculum activities, so extracurricular activities, and that's a specific legal obligation to do that, and a parent and a student with a disability has a cause of action to bring a discrimination complaint if they say that they haven't had reasonable adjustments made. So that's my first tip. My second tip is maintain good documentation. It appears to be a theme, as Sophie has said. Keeping good records and file notes is fantastic to be able to document the decision-making process. It's a risk management exercise, and whether those file notes and documents are later used under an FOI request, or whether they are subpoenaed by the court, or whether they're used in evidence in a claim, documents are your best friend. And we can help you with those. I've heard from principals I've talked to before have said, oh, I'm too afraid to put anything in writing. I understand that. My better advice is, if there is a decision that you think is risky that you would like to document, that's why we have a legal division phone number. Please give us a call because we can help you do that. And the last tip is, where appropriate, develop and follow detailed individual learning plans and behaviour support plans or behaviour management plans. I put that in as a tip because it's a theme we see over and over again, both in the complaints that advocates and parents make. It is so common to have the complaint of, you've discriminated against my child because they have challenging behaviour, a disability that is associated with violent and challenging behaviour or other challenging behaviour, and there was an appropriate behavioural support plan prepared and documented. And individual learning plans is again a theme that we see over and over again, and whether that's in correspondence or whether that's in claims before the tribunal or the court or one of the commissions, it's a theme, so it's a key recommendation. So to give you an illustration of why I've put those 3 top tips there, I want to give you a scenario, and it didn't involve any of the principals in this room because it was a primary school principal. And this is a bit of an extreme scenario because of the legal avenue that the parent chose to make, but it's actually a pretty common scenario that we see. In about the middle of September, I took a phone call from a principal of a primary school that they had a school theatrical play, a big production, not on school sites, down at the local town hall. 2 twin brothers were grade 4, I believe, were in the play, one of whom had a disability, oppositional defiance disorder, a query diagnosis of autism and definite challenging behaviours. But the family circumstances themselves were very complicated, and the other brother, who did not have a diagnosed disability, also engaged in significant violent and challenging behaviours. And it was a matter that the school had been managing, but it got to the point that the principal had made a decision that it was not safe for these 2 boys to participate in the school play, and she made that decision and she communicated it to the family, and she'd had a rather heated meeting with mum and I believe the aunt, who was legally trained, and at the end of the meeting the comment was made was, well, we're going to sue you for discrimination. So principal picked up the phone and called the legal division, and I had a conversation with her, and the first thing that we usually ask when there are issues with students with disabilities is, well, tell me about what happens on the ground at your school for this child. And then what we're really asking is, tell me about how you've made reasonable adjustments to enable this child to accommodate this child's disability so they can participate in their education. And participate means participate. It means derive a benefit from. It doesn't mean have a particular outcome. It doesn't mean that you have to make adjustments so the child gets straight A's, or that so the child gets the lead role in the play. It means participate. So we had the conversation, and the principal could tell me all of these great things that they did. There was a behaviour management support plan in place. the child with the disability had some aid time to help him function primarily in the playground, because that's generally where he came into physical conflict with other children, not so much in the classroom, but there was also sometimes an aid in the classroom. They had developed strategies for de-escalating his behaviour and developing empathy with him for other children, and then consulted with the child's treating practitioner as well as a regional SSO to develop this plan. So they'd made reasonable adjustments. When it came to the play, they'd taken further steps to try and have this boy have a successful participation in the play. They had put on extra staff for the rehearsals on a rotating basis, and those staff members' roles were to keep an eye on the boys, keep them safe, and de-escalate any conflicting events. But despite all of this, there had been an incident where there'd been a number of incidents, a number of warnings, including warnings to the boys that the play might be in jeopardy if you keep doing this. And of course that week they had both unprovoked punched another young student who was quite traumatised and didn't want to come back to school. So principal had made the decision that enough is enough. And I said to her, well, there's nothing that you've told me that gives me any reason to think that you haven't complied with your legal obligations to make reasonable adjustments. You're entitled to stand behind your decision. Go home, have a glass of wine, don't stress about it. If this matter goes further, if you get letters or any legal issues, let us know. Things went quiet, and then a few weeks later there was a letter, and it was a very legally worded letter alleging discrimination, and it came in, and I was about to go on leave, so one of the lucky other lawyers in my team got it, and he worked with the principal, and they developed a beautiful, documented, unemotional, clear response, thanking the family for raising their concerns, articulating all of the steps that the school had put in place to try and support the boy with the disability participate, also identifying clearly why the twin, who didn't have a disability, was not in fact lumped in with his brother, because one of the protected attributes under disability legislation is personal association with someone who has a protected attribute. So my association with my brother or sister who's homosexual, or my association with my mother who has a mental impairment, or in this case a boy's association with his twin who has a disability, that in and of itself is a protected attribute. And we documented how the boys were in fact treated very differently, and had both engaged in the violent behaviour and had both been warned, and therefore the fact that they had the same sanction of being barred from the play was actually not lumping them all in together. So we had this beautiful documented response, considered the issues raised by the family, but concluded, no, I'm going to stand behind my decision. Then at 10 to 5 on Friday night, we got court proceedings from the Victorian Civil Administrative Tribunal. Mum had lodged an injunction against the school to restrain the school from preventing the boys participate in the school play. That was on a Friday night. The school play started on Tuesday the next week, and the court was hearing the injunction on Monday afternoon. So this is unusual, I have to say, getting injunctions querying principals, or seeking the tribunals to overturn principals' daily run-of-the-mill decisions about what goes on in a school is not common practice. Usually what we would see out of all of this is a discrimination complaint.
Time's up.
Okay. That's okay. That's all right, we'll push on. But nonetheless, what we did was my poor colleague, who had since taken over the file, worked with the principal over the weekend, and we got a barrister, and we put in place evidence before the tribunal, an affidavit of the principal, and it exhibited her beautiful, well-reasoned letter. We rocked up in the tribunal for what the tribunal had said would be an informal hearing, but of course it's not informal as in the benefit of family who are saying, please let him participate. It doesn't allow us to educate the tribunal about the broader context of why this is a site off school grounds. Kids are coming and going in the wings of the play. They're in costumes. They might bump each other. Bumping each other in class is what sets off one of these boys in particular. The kids are excited. They're changing costumes. They're going in and out. It's a dangerous environment. The primary aim of the principal is the welfare and the safety of the students. And we popped all this out, and the tribunal initially had only read the family's long statement and started to have this discussion, saying to the principal, well, really, isn't there something that you can, can't you just, they're only in grade 9, can't you make up a part and have them in there? And then we said, well, have you read our evidence? Tribunal stood it down, went away, read the principal's affidavit where she detailed all of the safety issues, all of the steps that had been put in place, and came back and said, no, I agree. Case dismissed. So it's a long story, but the reason why I tell it is because it hit all of those key points. We'd already had reasonable adjustments made. We'd already had good documentation. We already had a behaviour support plan. Now, we don't know what action a family is going to take, and we actually don't know what decision the court's going to make in the end. But these three things really protected this principal, and I heard that the play was a great success, and in actual fact, the boys never wanted to be in it in the first place, which is, probably a story I'm not unfamiliar with. So that we have a chance to have questions, I've provided the slides. I hope you have it. It's just got some more detailed content in it about what discrimination law is. The fact that under the law, the definition of disability is broad, and it does not mean students who are on the PSD. The courts and tribunals do not care what particular funding program we have for a particular cohort of students with disabilities. The only reason that is relevant is it might go in the broader context to reasonableness. What is more reasonable in a situation where we have a funding program that might allow aids and other more expensive adjustments for a particular cohort might not be reasonable for some other students, but the obligation is to make adjustments for all students with disabilities. What those are don't always cost money. Frequently and usually they don't. An adjustment might be modifying the way that the teacher interacts in the classroom with the students, the way that instructions are delivered, the fact that a kid with a vision impairment can sit closer to the classroom or can do some more work on an iPad. It might be having a behavioural management plan. It might mean that teachers who are on yard duty have a particular focus on a particular student. The vast majority of reasonable adjustments don't cost money. Some of them do, and unfortunately, if what is required is beyond the budget of the PSD, then again the court doesn't really care, and so we need to look at other creative ways of finding those adjustments. How we make our decisions about what a reasonable... I was told to be careful about not pressing the wrong button.
Michael.
Oh, the battery of the entire computer's flat. Yeah. Great. All right, let's go away from the slides. All I was going to say about reasonable adjustments is it's about what's reasonable in all of the circumstances. You are required to consult, so consulting with the student and their family and taking their views into account. If they have private treating practitioners who have recommendations, great, take them into account and consider them. But at the end of the day, as Kate said, you are the decision maker, and there's a reason for that, and that is that you know the big picture. You know what an adjustment is to enable that children to participate in the curriculum or the educational program. The family don't necessarily know that. You know that if what the family are asking for would actually change the nature of what your educational program is, then it's not reasonable. You also know the impact on other students and the impact on other staffs and the physical location of your school. There are lots of things to weigh up in making a decision about what is a reasonable adjustment. And just because something might be done in one school doesn't mean it's not that if you do something else in your school, both can be reasonable adjustments. Or just because the parents want one particular thing, if you think it's reasonable to do another particular thing that that has the same endpoint of enabling your student to participate and access their education, still reasonable. The other points I've put in the slides are a bit like what Sophie said, keeping good documentation, using information appropriately. You get information about your students' disabilities for the primary purpose of providing them an education which makes reasonable adjustments. Therefore, you can use it for that. It's no good popping it in a drawer and leaving it there. The teachers who need to know and the staff members who need to know should know. You can use it for different classroom teachers for the yard duty, and even if the children change schools, we're still the same entity. This department, this Victorian Government department, uses that information for the reason for which it was collected. So make sure those that need to know about what recommendations have been made from treating practitioners or what decisions have been made by you, the principal, in consultation with your SSG, are for this particular child. Now I'm going to leave it there so that we can ask any questions.
We've got time for just a couple of quick questions, but
Okay,
preferably
so
not too specific.
Yes, so if they're very specific,
Michael,
give us a call.
There's a microphone behind you, Michael.
Recently we received a big list of delegations from the department, you know, the things that principals now delegated to have authority to basically deal with, sign off on, etc. From a legal perspective, I guess you'll have to do it in a snapshot way, what are the implications of that for us as the decision maker in the school?
So they're presumably statutory delegations. So in a piece of legislation, the legislation will often say the minister has a power or function to do certain things, or the secretary does, and the secretary is the employer. But the secretary can't personally, individually carry out all of those functions and duties, given that there's 60,000 employees. So it's widely accepted that the secretary can delegate those functions to other people. And you'll often see that in a delegation instrument with a schedule that will contain the types of things that have been delegated and to what level. So you might have a certain function that's given to the secretary, delegated to a regional director, delegated to a principal, delegated to the executive director of HR, for example. It gives you the power to make a decision. The first thing is you have to exercise that function or make that decision in accordance with the terms of the delegation. So the delegation might contain a limitation in relation to the use. And you also need to carry it out in accordance with policy. So there will be a policy on HR Web that would set out who generally makes what decisions, and then there's just an underlying legal instrument. The delegation really is the underlying legal instrument. It should be consistent with department policy. So I would say you follow the department policy, and the instrument underlying that means that when you exercise that decision, you're within your power to do that.